I'd like to welcome everybody here. My name is Neil Halverson. I'm an assistant district attorney during the day, and during the evening I teach as an adjunct here at Mercer, teach trial practice. And so I want to welcome everybody here to the annual closing argument competition. So let me just make a few opening remarks, and then we will begin the actual competition. First of all, as a courtesy to our participants, and certainly to the panel of judges that we have sitting as jurors, would request, if you haven't already, to make sure you silence your cell phones, and so give everyone an opportunity to do that. I teach trial practice here at Mercer and have been doing that for several years, and one of the reasons that I enjoy teaching trial practice, and one of the things that is certainly important for Mercer, is that when the students graduate from Mercer University Law School, we want to make sure that they are trial ready. We want to make sure that the students that come out of Mercer are comfortable coming in front of a judge, coming in front of a jury, and arguing and presenting the case. And this gives students the opportunity to get a taste of what it's like to be in front of a judge and in front of a jury. And so we certainly appreciate the students that have done this competition and are looking forward to this final round. As some of you may know, we apparently began with 56 students, and we are now down to our final two, and I want to take a moment now to introduce those to you, for those of you that don't know. Representing the prosecution, we have Victoria Nease. Victoria comes to us from Savannah, majored in psychology at Armstrong State University. Is that correct?
That is.
All right, so welcome, and good luck to you, Victoria.
Thank you.
Representing the defense in this particular case, we have Davis Lackey. Davis comes to us from Lawrenceville. He's a communication major at the University of Georgia. Is that correct?
Yes, sir.
All right, excellent. So good luck to you, sir. Good luck to you, man, and looking forward to the competition. I'd also like to take a moment to thank our sponsors who have worked very hard to put this competition together. Law firm of Childress and McCain. We would also like to thank the law firm of Reynolds, Bourne, and Servant. There will be a reception immediately following the final competition, the final round. The reception will be in the kind of waiting area, the gathering area, out the back doors behind the courtroom. And so certainly invite everybody to come and partake of the reception immediately following. I think it would be appropriate at this time to also recognize and thank individuals with the MAC, Mercer Advocacy Council, and student volunteers who have worked to put this competition and other similar competitions together throughout the course of the year. The MAC president is Gabrielle Clifford. The mock trial chair is Tiara Williams. Closing arguments director is Gabrielle Biggs and Courtney Chester. And finally, I would like to thank all of you. I would like to thank everyone here in attendance for coming, for being here to support this competition. Looking forward to a great presentation, and I'm confident that we will have a great presentation. At this point, I will turn the matters over to our presiding judge, who's going to be Judge Sims in this particular case, and Judge Sims will be here. Judge Sims is the Chief Judge of the Macon Judicial Circuit, and he will be presiding over the case for the closing argument competition. Thank you.
All rise. Please remain standing for the judge.
you, sir.
Ms. Nease, the state has the right to open and conclude. You have the floor.
Thank you. I'd like to reserve 1 minute for rebuttal. May it please the court. My name is Victoria Nease, and I represent the state in this case. Your Honor, counsel, ladies and gentlemen of the jury, good evening. Clay Morrow had so much life left ahead of him. He was a young man with an exemplary past and a bright future. A future that promised to be everything that anyone could hope to, but a future violently and tragically cut short by the defendant. Now, we, the state, have the burden in this case, but it is a burden that we have met. Now, this might be a bit confusing, so let me give you an example. When you go to sleep at night, you wake up, and there are puddles covering your front lawn. You might think to yourself, maybe your neighbor woke up in the middle of the night and sprayed your front lawn with a garden hose. Maybe it was a sprinkler system. But if there are dark clouds overhead and you hear thunder in the distance, you can reasonably believe that it has rained. Now, the defendant has been charged with voluntary manslaughter. Let's look at the elements of this crime and why we, the state, have met every element. The first element: the person causes the death of another human being. The testimony of Hector Salazar, the only eyewitness to the events, tells us that he exited the Jeep and rushed over to see if his friend was okay. When he got close, he saw this knife protruding from his friend's chest. He was not moving. He was not breathing. He had no pulse. And the testimony of Detective Wayne Unser reinforces this. Detective Unser tells us that he arrived at the scene and that Clay was already dead. The defendant took the life of another person that night. The second element: the defendant acted under a sudden, violent, irresistible passion resulting from serious provocation. Now, the defendant left his house that night angry. He had just had a blow-up conversation on the phone with his girlfriend. He admits he was driving fast, attempting to weave in between lanes. He was driving aggressively. Clay, on the other hand, they had merely left their house that evening to go see a movie with friends. They were having a peaceful night until they encountered an aggressive driver. Now, Hector tells us Clay loved his Jeep. So when the defendant cut in front of him, almost hitting his car, Clay was upset. He honked on his horn, and the man in front of him slammed on the brakes, almost causing a collision. This put Clay in fear of their safety. So when the car pulled off the road, the Jeep pulled in behind him. Now, the defendant testifies that he pulled off the road to call his girlfriend, that he pulled over to be safe. Ladies and gentlemen, this man just told us that he was speeding and attempting to weave between lanes. Why is he all of a sudden so concerned with safety on the road? And to top that, he was later pulled over that night for texting and driving. A story full of inconsistencies. What happened is the defendant pulled off the road, angry, the altercation that had taken place with his girlfriend. He wanted Clay to pull in behind him so that he could release the anger that he had been feeling. Clay was a casualty of that anger. Now, the third element is that the provocation was sufficient to excite such passion in a reasonable person. Now, there are only two people still alive that know what happened that night, and you have heard testimony from both. I want you to weigh the credibility of these witnesses. Hector tells us that Clay got out of the Jeep and began to walk over to the defendant's car. The defendant exited and charged and tackled Clay to the ground, lifting his hands above his head in what Hector thought was a punch, but was a fatal stab wound. Now, Hector has never seen Clay with a knife, and they live together. They're friends. So if Clay always carried a knife on his person, protector would know that. Now the defendant is doing everything in his power to preserve his freedom. So he has every reason to lie. And Clay, be here to testify for you tonight. Because the defendant took away that right. Now what happened that night is that the defendant pulled off the road, angry, blood pumping from the road rage and the altercation with his girlfriend. Now we know that Clay is 6'1", 220 pounds. So the defendant looks in the rearview mirror and sees him walking towards the car. We know the defendant is 5'8", 170 pounds. So he sizes up Clay, reaches down to grab the knife that he keeps in his car, and exits the vehicle, ready to fight. Now, road rage is enough to make any reasonable person angry. But road rage, coupled with the instability and fury of the defendant, took him beyond the bounds of anger and catapulted him into a rage that took the life of an innocent man. Here we have all three elements. And the defense wants you to believe that none are present. But you see the clouds, you hear the thunder, you feel the rain. Now the defense wants you to believe that Clay was the one with the knife, that he was the aggressor. Ladies and gentlemen, Clay was a football star and a fitness nut that had shattered many weightlifting records. The defendant wouldn't have stood a chance against a man of this stature. He would not have been able to wrestle away the knife. No, the defendant was the one holding the knife. And the testimony of Dr. Tara Knowles tells us that the defendant did have a busted lip, but he didn't have any evidence that he had thrown any punches. Ladies and gentlemen, you don't need to throw punches when you're the one holding a knife. Now, the fingerprints at the bottom of the knife tell us that Clay tried to defend himself. But the 4 fingerprints from the defendant on the knife show us that he was the one grasping it. Now, there is a laceration on the defendant's arm, but this is proof that Clay did everything in his power to defend himself. But everything happened too quickly. He was blindsided, and he was not able to save his own life. Now, what says guilt to you, ladies and gentlemen? The defendant fled the scene. If it was an accident, why not stay? If he was afraid, why not call the police? And if he was so innocent, how did he have a clear enough head to dispose of clothes covered in blood that could be used as evidence against him? These are the questions to ask yourselves, ladies and gentlemen. These are the actions of a guilty man. We, the state, have proved every element of voluntary manslaughter. We have proved the defendant guilty beyond a reasonable doubt for taking the life of an innocent man. We ask you to think of the justice that Clay's friends and family deserve. They will never see him walk across the stage to get his degree. They will never see him play another football game. We ask you to return the only verdict that justice demands, a verdict of guilty. Thank you.
May it please the court. My name is Davis Lackey, and I represent Jax Teller in this case. From apology to fatality, Jax Teller was faced with the decision to defend his own life. In the state of Mercer, a person is justified using force when he reasonably believes that such force is necessary to prevent great bodily harm or death to himself. The state wants you to believe that Jax was the aggressor in this case. But you have seen evidence and heard testimony throughout this trial that shows that this cannot be the case. The state has the great burden of proving all the elements of voluntary manslaughter beyond a reasonable doubt. Now, the phrase beyond a reasonable doubt can be kind of abstract. So let me put it to you in this way. The prosecution is building a ship using just the evidence in this case. The government's burden is to construct a ship that is fit for a long and lengthy voyage. At the end of the prosecution's construction, they're going to be asking you, members of the jury, to climb aboard and sail across the sea. I want you to examine, investigate, and see if there are any holes or cracks in the prosecution's ship that would hesitate you from climbing aboard. I suggest to you that if you find any holes or cracks in the prosecution's case, that you have found a reasonable doubt. On February 26, 2018, Mr. Teller pulled his vehicle into the Everything's a Dollar parking lot. He realized he cut off a vehicle in traffic. He looked in his rearview mirror and saw the Jeep pulling in behind him. Jax Teller intended to apologize. Jax opened his door, looked behind him, and saw the driver of the Jeep, Mr. Morrow, sprinting in his direction, cursing and screaming. When Mr. Morrow was close enough to Jax, he shoved him and swung on him. He missed, and the two fell to the ground. At this point, Jax felt a sharp pain on his left forearm. Mr. Morrow pulled a knife on Jax Teller. Jax did everything he could to fight back and swat the knife out of Mr. Morrow's hand, and it fell to the ground. Clay Morrow reaching back for one more knockout punch. Jax grabs the knife, closes his eyes, takes a stab in the dark. Worried, anxious, and nervous about the passenger in the Jeep coming to attack Jax, Jax gets in his car and drives to the hospital to seek help. Now, the prosecution's case rests heavily on the biased testimony of Hector Salazar, and two key points need to be addressed concerning the validity of this witness's statements: his location and his intoxication. I'd like to show you a map of the parking lot that night. And you can see this J here, where Mr. Hector Salazar was, and the Pontiac, where the events occurred. You can see these two lanes here, just like every parking lot has. But 25 to 30 yards separating the two parties. You heard Mr. Salazar say, because it was dark that night, he could not see whether or not Jax was holding a knife in his hand. Secondly, Mr. Salazar was intoxicated at the time of the events that took place. You heard him say that he was drinking that night. That's the reason why Clay drove his Jeep. How are we to believe the biased statements of a witness who was separated 25 to 30 yards, surrounded by darkness, and intoxicated at the time of the events? The state also wants to highlight the fact that Jax Teller's clothing is mysteriously missing. Let me ask you something. How many bloody articles of clothing you think come in and out of a hospital on a given day? 15? 25? 50? The fact is, doctors and nurses deal with bloody clothing every day. Ms. Knowles was not looking for bloody clothing that evening. Do not fall for the prosecution's tricks into thinking that Jax was trying to conceal his guilt. There is no guilt in this case. I'm hoping that you're beginning to see that the prosecution's case is not fit for a long and lengthy voyage at sea. Certainly not with you in it. the most fascinating piece of evidence in this case that the state has failed to address and pokes a hole, big gaping hole, in the side of the prosecution's case is the fingerprint analysis. The fingerprint analysis shows us two things. One, this was not Jax's knife. And two, Jax was not the aggressor. Now, the fingerprint analysis shows that two individuals were holding a knife that night. That's right, Mr. Morrow and Jax. But, and the state highlighted this a little bit, Mr. Morrow's fingerprints were found at the bottom handle of this knife, right here. For those, his right index finger and right thumb. Now, typically, when someone carries a knife of this size, they use their right index finger and right thumb to pull the knife out of their pocket. It's easy to put in. It's easy to take out. This was Mr. Morrow's knife, not Jax Teller's. Also, Jax's testimony and wounds line up with the fingerprint analysis. If Jax Teller is lying on his back like this, and Mr. Morrow is straddling him, his lower stomach area, Mr. Morrow pulls out the knife, flips the blade open. It would make sense that Jax Teller would have an incision on his left forearm. Mr. Morrow was the aggressor, not Jax Teller. From apology to fatality, Jax Teller was faced with a decision to defend his own life. Jax quickly became the victim in this case. Jax, feeling outnumbered and worried that the passenger and the driver was going to come attack him, and brutally overpowered by Mr. Morrow, Jax did the only thing a reasonable person in his position would do to defend his own life. Jax was not the aggressor. He was trying to offer an apology. As a jury, you have tremendous power to render a decision that will manifest justice and truth. The prosecution ship cannot and will not make it a nautical mile at sea. The prosecution has not met their burden in this case. The defense asks that you return a verdict of not guilty. Thank you.
The defense just tried to discredit what I said by using fingerprint analysis. But what he failed to tell you, he says, you pick up a knife out of your pocket, but if he was trying to stab Jax, the defendant, then why did Jax's fingerprints, why were they grasping the knife? You can't try to fight someone holding just the bottom of the knife. If he was really trying to be the aggressor and the one holding the knife, his fingerprints would have been the one covering the knife. Clay's fingerprints would have been holding the knife, not just at the bottom. And if he wasn't trying to conceal guilt, if he was so innocent, why didn't he call the police first? Because an innocent person who just did something in self-defense, they would still be concerned about that person, hoping that they weren't bleeding out to death. Maybe someone could come and save their lives. If you're going to get your injuries checked, call the police so that maybe an ambulance can come and potentially save this person. Then you've gotten yourself out of the situation, and then a person is not dead. There is no greater fear than what Clay felt, being stabbed in the heart, bleeding out, on cold pavement, alone in an empty parking lot. And we ask you to give him justice and return the only verdict that justice demands, a verdict of guilty. Thank you.
Thank you, counsel. Thank you, jury.
All rise. Wow. I was feeling like emotion.
Your body language and the way you move your hands and fingers.
I almost cried.
One of the things that I started with was that one of the goals of our law school is to graduate attorneys, students who are trial ready. And I think we can all recognize that what we just saw were two students who were trial ready. So we gave them a hand before, but I think it'd be appropriate to give them another hand. If I could, just, I know the information is on there, but would also like to thank the jurors who are serving in this capacity. I believe everyone has the list of the jurors. It's quite a distinguished group of individuals who serve our community in a variety of different areas in private practice, criminal defense, criminal prosecution. And I think it speaks volumes for the university that these individuals are willing to come back, take some time out of their busy professional careers and judge this competition. And so while they're not here, we understand they're back deliberating. I do think it would be appropriate to recognize and thank the individuals who have agreed to serve as jurors in this particular case as well. So if we can give them a hand. One of the things that I share with my trial practice class the first day of class is a quote from Theodore Roosevelt that many of you might be familiar with. And I think it's an appropriate quote because it sets the stage for what we've talked about, and that is graduating students who are trial ready. The quote is as follows, and at one point I'd love to memorize it so I can give it to you verbatim by memory, but I'm not there yet, but I'll continue to strive there. It is not the critic who counts, nor the man who points out how the strong man stumbles, or where the doer of deeds could have done them better. The credit belongs to the man or women who's actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes up short again and again. Because there is no effort without error and shortcomings, but who does actually strive to do the deeds, who knows great enthusiasms, the great devotions, who spends himself in a worthy cause, who, at the best, knows in the end the triumph of high achievement, and who, at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with the cold and timid souls who neither know victory nor defeat. I think that sets the stage and is a quote that I think is appropriate for encouraging individuals, law students, to get in the arena, to try cases, and to make the effort to present the case and argue the case on behalf of his or her client. And so we just saw an example, two examples of that here this evening. And so once again, I would thank Virginia and Davis. Great job, both of you, and look forward to the verdict from the jury. But I think we can all recognize that regardless of what the verdict is, both of you did a phenomenal job. Thank you. I've been told that the jury has a verdict, so if we could have everyone, excellent, perfect. Thank you very much. And I believe I will receive the verdict. Thank you.
Good evening, I'm David Cook, I'm the district attorney.
I'm Rick Waller, I'm the public defender.
I'm Shay Young, I'm assistant district attorney. I'm Christy Childers, I'm a partner at Childers and
And I'm Kristen Quinton. You'll see me all week. I'm a supervising attorney with the Public Defender's Office, and I work for Mr. Waller.
I'm Jim Fleisner. I'm on the faculty here at the law school.
My name is Megan Tuttle. I work for the Public Defender Office with Mr. Waller and Ms. Clinton.
I'm Scott Key, I'm in private practice.
I'm Virginia Josie. I work for Nolan Law Firm.
Michael Mayo, partner, Mayo Hill.
Hi everyone, I'm Lauren Wilmer and I'm the staff attorney for the teacher union here in Georgia.
Mr. Howerton, did you draw that?
No, sir.
Oh, good. All right. I'm down there now. Mr. Cookburn, all right, in the interest of time, I know we're gonna do it a little differently than we've done it in past years, and Mr. Cook is gonna give us some commentary that comes from the conversation we just had in the back as to the state's attorney, and then Mr. Waller is gonna do the same for the defense attorney, and then I will announce the winner. All right, Mr. Cook.
Ms. Nease? Yes, you did a fantastic job. So what we all noticed was how you really exuded poise and professionalism. That part just really ran through everything that you did. You had a command of the facts. You were comfortable, you were confident, you had an effective use of logic. So all of those things were good. Also, there was how you were working on inflection. We noticed that. Just very, very polished overall. Then some critiques with one that struck me, and I realized that part of this may be the rules that you're governed under. But there's a phrase I use. Alice was down the rabbit hole and on her way to Wonderland by the bottom of page 1. Okay, so the idea is you want to get into the story immediately. Now that may apply more to opening sometimes, but you need to think about that in closing argument, is that you want to get to impact, you want to have the jury's attention right away. So I realize you're following to some degree of formula, but something to keep in mind is that. Another one that's a picky thing for me, and I realize that everybody teaches y'all to say, ladies and gentlemen of the jury. There's going to come that day where it's ladies and gentlemen, or lady and gentlemen, or all ladies or all men. And so to me, I think you should ingrain the phrase members of the jury into how you address the jury, because that works every single time, being gender neutral. So I recommend that. One other positive thing I want to come back to is, so most of what you did, as I mentioned earlier, was very logical, very, very calm. But when you came back to rebuttal, and then you ended bleeding out alone in an empty parking lot, like, okay, that you want more of that in your close. But that was a perfect way to end it. But never let go of the idea that in closing, that is where you want to hit them with emotion as much as logic. Right now, y'all are in an environment that encourages you all to be all about the law, and fairness doesn't really matter, okay? It's not about fairness. There was a professor here for the longest time who'd say, don't talk to me about what's fair, okay? When you're talking to the jury, it means everything in the world. Everything in the world. That's when fairness matters. So those are just a few things that I wanted to mention, but again, I thought you did an excellent job.
Mr. Waller.
And after the defense. First of all, you both did a great job. We all agreed on that. It was really clear that you were yourself here, which if no one's mentioned that, that's important. You can't be anyone else when you're in the courtroom. You can always tell when there's an attorney that's trying to be someone else, because it just doesn't come across as natural or real. But clearly, were being yourself. You used the space well. You were passionate about defending your client. We liked that we got a good opportunity to look at the exhibit when you showed it to us. see what was in there. A small criticism about that is I probably would have wanted to see how close Clay was to Jax's car on that diagram. Because he was a little closer maybe than the state might indicate with their words about where he was. Because if I remember, he hopped out of the car and immediately got tackled, but the diagram, I think, showed something a little different. So if that would have been helpful to point that out too, is why you were showing the location of the vehicles. But you're also doing a very good thing at a time. You're going after the state's witness really hard, which was good. You had a lot of things to work with there. So, good job.
All right, now I get to announce the winner. Before that, though, I get to take judicial privilege and say that I've done this for several years in a row now, and I'm always truly impressed by the ability of first-year law students to come in here and make these kinds of arguments. When I was a first-year law student, that was the last thing on my mind. I was wandering around the hall with my eyes open, my tongue hanging out. And and I say this honestly, I'm not making this up, I'm not trying to make you feel better about yourselves. I've seen real lawyers do it worse than both of you, okay? I see it every trial time. So I truly was impressed, I really was. And after the vote, it is my pleasure to announce now that Davis Lackey, you have been declared the winner of the competition.